I'm attorney Laura Schultes with RSH Legal. We get a lot of calls about harassment in the workplace. Sometimes this harassment takes the form of a generally hostile work environment, repeated inappropriate jokes or scattered comments and gestures here and there. But other times, the harassment arises in a situation that the law calls quid pro quo harassment. Quid pro quo is just a fancy way of saying something for something, or this for that. It is a type of harassment where a supervisor or a manager suggests that an employee do something in exchange for something else. Most often, this kind of harassment can come up in the context of sexual harassment. For example, your boss or a supervisor could ask you to go out on a date, and in return, offer a raise or a promotion at work. If you refuse, you don't get the raise or the promotion, or worse, your employer fires you. This kind of bargain, if it is based on something like sex, race, religion, age, or disability, is unlawful, and you might have a case of harassment against your employer if it results in harm to you. Proof of harm may mean showing something like a demotion, a denial of a raise or a denial of a promotion, a poor performance evaluation, verbal or written warnings that are not supported by the evidence and are unwarranted. In order to recover for these kinds of harms, an employee will need to establish that the negative employment consequence was caused by the quid pro quo harassment. Certainly, a close time frame between the harassing conduct and the negative consequences can be strong evidence of that causal connection. But other factors, such as the harasser being the sole decision maker on employment benefits, or the harasser's behavior following the inappropriate conduct, can also help establish that causation link. If you have experienced quid pro quo harassment at work, there are a few things that you can do to protect yourself and your claim. First, report the harassment as soon as it occurs. Many companies have procedures within employee handbooks that cover topics such as how to report harassment. Some companies even have a hotline that you can call. If your company has specific procedures to follow, you should follow those procedures. If your employer does not have policies that explain any sort of reporting procedure, then report the harassment in writing to someone who fills a human resources type role. Keep a copy of the complaint that you submit for your own records. Second, when you submit the complaint, describe the harassment in detail. Sometimes it's not easy to report harassment, but it's important that you do so in as much detail as you can. Include the exact words that were said or physical contact that might have occurred. If you believe that you were targeted because of your sex, your race, your religion, a disability, your age, or a similar reason, you need to clearly state that. You should also gather all inappropriate text messages, emails, notes, or other evidence that might support your claim. Keep these documents in a safe place somewhere away from work. And keep copies of all documents related to your internal complaint. Several different types of damages could be possible for you to receive in a successful harassment settlement or verdict against an employer. These types of damages include things like the emotional pain and suffering that being a target of harassment can cause, such as the anguish, humiliation, depression, and anxiety. You may be able to receive compensation for those things. If the harassment has resulted in some lost wages or other economic losses as a result of the quid pro quo harassment, you are entitled to be compensated for those losses as well. If a case involving this type of harassment goes all the way to trial and you win a jury verdict, the attorney who represented you can also request reimbursement of attorney's fees and expenses. RSH Legal offers a free, no-obligation case evaluation to Iowans who have been harassed on the job. To schedule yours, call 1-800-433-0283 today.